at paragraph 38 on page 57, comparing and contrasting iPad with the DPCI walks. The court says that Section 6 of the iPad Act gives the minister enormous political powers and control over the executive director of iPad. It gives the minister the power to remove the executive director of iPad from his office without parliamentary oversight. This is antithetical to the entrenched independence of iPad envisaged by the Constitution, as it is tantamount to impermissible political management of iPad by the minister. To my mind, this state of affairs creates room for the minister to invoke partisan political influence to appoint someone who is likely to pander to his whims and who is sympathetic to the minister's political orientation. This might lead to iPad becoming politicized and being manipulated. Is this compatible with iPad's independence as demanded by the Constitution and the iPad Act? And the court says certainly not. Paragraph 39, to subject the executive director of iPad, which the Constitution demands to be independent, to the laws of governing the public service to the extent that they empower the minister to unilaterally interfere with the executive director's tenure, is subversive of iPad's institutional and functional independence, as it turns the executive director into a public servant subject to the political control of the minister. Without adequate independence, it would be easy for the minister to usurp the power of the executive director under the guise of exercising political accountability or oversight over iPad in terms of 206 of the Constitution. In this case, acting unilaterally, the minister invoked the provisions of Section 16A1 of the Public Service Act, placed McBride on suspension, and instituted disciplinary proceedings against him. Undoubtedly, such conduct has the potential to expose iPad to constitutionally impermissible executive or political control. That action is not consonant with the notion of the operational autonomy of iPad as an institution. Put plainly, it is inconsistent with Section 206 of the Constitution. It follows that it is invalid and must be set aside. And then the last paragraph I want to refer to, paragraph 43 on page 59. To my mind, the cumulative effect of the impugned sections has the potential to diminish confidence the public should have in iPad. As the amicus curiae emphasized in its submissions, both the independence and the appearance of an independent iPad are central to this matter. The manner in which the minister dealt with Mr. McBride demonstrates without doubt how invasive the minister's powers are. What exacerbates the situation is that he acted unilaterally. This destroys the very confidence which the public should have that iPad will be able, without undue political interference, to investigate complaints against the police fearlessly and without favor or bias. iPad must therefore not only be independent, but must be seen to be so. Without enjoying the confidence of the public, iPad will not be able to function efficiently, as the public might be disinclined or reluctant to report their cases to it. Do you want to comment on this? Because this also speaks directly to some aspects of the Honourable Committee's terms of reference. But how does one, or how does this committee recommend to Parliament that trust and confidence be restored, not only in the police, but also some of the other arms of security in the country.
So, for example, the GPCI is still under.
Honorable Mathis.
No follow-up question. Just Senior Counsel, please speak into the mic. You extra soft today.
Sorry, Honorable Matthys. My apologies.
So, in response to the question, Honorable Chairperson, is a good example about non-implementation of Constitutional Court judgment is DPCI. DPCI is still under the National Commission of Police. DPCI is, its own budget is controlled, it's on the same budget as SABC. It doesn't have, as this judgment indicates, structural and functional independence. When DPCI has to appoint a specific person, DPCI has to ask SABC HR to stand in and decide. So we've contravened a number of judgments on that. In the issue of IPID, and as we've seen in recent years, IPID should move away from Minister of Police, as the Minister of Police is the head of a department, political head of a department, over which IPID has investigative oversight, including criminal investigations. And therefore, the minister would have an interest in controlling the outcomes. And that is our experience within IPID, various stages and various forms. And perhaps later on, I will come to that during questioning. So those are the issues. So there's still some outstanding legislation, probably for the work of the National Assembly to correct and implement, so that we do not have a repeat of inquiry after inquiry when police systems go wrong. And in that way, we need to fix the systems first. And a clear way to fix the system is the anti-corruption bodies need to have the necessary independence to be able to exercise an investigative oversight over them. If it's not there, it's just another form of control by the minister. Indeed, the forerunner to IPID was the ICD, which was part of the SABC, and it took a lot, and it's still work in progress, to get the mind of independence of IPID workers right, because some of them still have relationship with SABC, and it goes to them being colleagues before and so on, and so it does affect their work. So, yes.
Thank you. Just to round off on the rendition issue of as the amicus curiae emphasized in submissions, both the independence and the appearance of an independent. Can we just reference at items 8 and 9 of the index annexure RJM 6A and RJM 6B? 6A is the rendition report. At page 186 to 213, and the Waxman's report is from 214 to 287.
Yes, I have.
So So this particular report on page 186 that was the 1st January 2014 report.
Yes, yes.
And one can see from page 213, on page 213, Mr. Kuba, then the acting provincial head of IPID Limpopo, said based on the available evidence, IPID recommends that Lieutenant General Dramat, Lieutenant Colonel Maluleki, Constable Khadebi, Captain Kosi, and Warrant Officer Maku be charged criminally of kidnapping, defeating the ends of justice, assault, and theft. And of interest is at page 207. At page 207, there is a statement, a reference to statements taken of senior members of SAPS. And you'll see in the middle of the page, Lieutenant General Mkhwanazi.
Yes, sir.
Do you want to comment on that passage? Or do you want to read it again?
Is that 5.6?
5.6, yes.
Okay. So in context, this is Kuba writing about his interaction with General Mkhwanazi then, and what General Mkhwanazi will indicate about his knowledge of the rendition. He will state that in late 2011, when he was acting National Commissioner of the South African Police Services, he heard news when Minister Khadebi was commenting about the alleged death of a Zimbabwean citizen as a result of being handed to Zimbabwean authorities by South African Police Services. He immediately contacted the head of GPCI, Lieutenant General Dramat, and inquired about the issue. Lieutenant General Dramat confirmed that members of his unit did transport Zimbabwean citizens, but as illegal immigrants. He then summoned General Dramat to his office. Lieutenant General Dramat came with an officer who was introduced to him as Cowboy. He was informed that Cowboy was in charge of the group that transported Zimbabwean citizens. Cowboy said that he was investigating a case of ATM bombing, which led him to the Zimbabwean citizen. After he realized they were not linked to the case, he decided to transport them to Beitbridge because they did not have valid documents. Cowboy further said that he got valid deportation documents from Home Affairs before he could transport them. He would state further that he could not understand why Cowboy did not hand over immigrants to Home Affairs when he asked whether it was necessary to transport illegal immigrants. Lieutenant General Dramat could not offer any explanation.
So there wasn't any further or other input from General Mkhwanazi to Kuba?
No, so according to these documents, no.
Okay. Then the next reference is the Waxman's report on page 214. There's no reference to Mkhwanazi or whether or not he was interviewed in the compilation of this report.
Not that I'm aware of yet.
And this report also recommends, and it's apparent from page 285, the section on recommendations.
Yes, I have it.
You see that Dramat, for the reasons set out at 531, we recommend that both criminal charges and disciplinary charges be brought against him in his capacity as an employee, and similarly for Sabia.
Yes.
Now, the third report is the one that is not not an annexure, Honorable Chair, Honorable Members, to the affidavit, but we have now included it late in the exhibit bundle. So I'm sure that hopefully by the time you ask questions of Mr. McBride, you would have had an opportunity to look at that report. That's the final report.
Yes, indeed.
Did you interview, amongst others, General Mkhwanazi in the compilation of that report?
No. I was not involved directly in the investigation, and I'm not sure if the others spoke to him again. What was done was the inclusion of the cell phone records analysis report to indicate whether the cell phone analysis report will confirm the suspicions or exonerate the suspects. And in this case, so even what Kuba did, he took the official phone of Sibia, and unbeknown to Sibia, the number of the private phone, and checked both of them. Those phones were together all the time, and they were nowhere near the crime scene as explained by witnesses. So it's not sustainable any longer to continue to suspect him and recommend prosecution.
Now, can I ask you to turn to Annexure RJM 8, which is on page 305. That is the affidavit or the sworn statement of Matthew Sissoko, an affidavit that he made to the Zondo Commission.
Yes, sir.
It's at page 307. And that affidavit was deposed to on the 20th of November 2019. That you can see from page 314.
Yes, sir.
And he mentions at 307 paragraph 2, he says at the onset it was important to note, he introduces himself and says, I'm responsible for all provincial and national investigations of the directorate. I report directly to the executive director. Is that still his position, do you know? Mr. McBride?
No, my understanding is that Sissoko is now part of IDAC. As a permanent staff member in IDAC and head of investigations.
He says at the onset, it's important to note that I specifically asked the lawyers who were interviewing me what the status of the inquiry was and whether I was being investigated for misconduct or any criminal offense. To which they replied that the minister merely wanted to understand the circumstances surrounding the two reports. Then he also attaches a transcript of the interview. And he only participated without legal representative on the basis of this assurance. In paragraph 3, this notwithstanding, when the report was released, which was not officially given to us, but rather leaked to the Sunday Times newspaper,
Indeed.
It was recommended that I be charged criminally and departmentally without even affording me an opportunity to deal with the allegations against me. When you objectively look at the totality of the evidence in this matter, it is apparent that although Kuba signed the so-called first report with the recommendation that Ramat and Sabia should be charged, he regarded the report as an interim report, as he was aware that investigations were outstanding. Mosing and Moletsi came to a different conclusion relating to charging Sabia, concluding that there was no evidence to support the charge, and also indicated that expert evidence on cell phone records needed to be procured. They both regarded Kuba's so-called first report as a draft report and marked it as such. The report emailed to me by Kuba after sending the so-called first report to Mosing does not recommend charging Sabia. See the email and the report attachment marked MS3. What was sent to me was his amended first report, which amended the recommendation that Sabia be charged. The decision arrived at by both Mzinyati and Beloy, were they at the time prosecutors, Mr. McBride,
Yes, sir.
in the NPA,
That's correct.
without having regard to the so-called first report signed by Kuba and the final report signed by myself, Kuba, and McBride, is different from the recommendation of Mosing and Moletsi, as they decided that both Ramat and Sabia should be charged. So too the report, which is the final report signed by myself, Kuba, and McBride, concludes differently, that there is no evidence to support the charges against Ramat, Sabia, and other officers. So what was Mr. McBride, what is the upshot of all of this?
Is that the NPA itself, senior members, were also of the view that it was an incomplete report. And they said so in writing, and some even wrote the word draft. And it's therefore no surprise that when the additional evidence is added, which shows a different perspective on the matter, that the recommendations from IPOD would be that charges against Sibia and Ramat are not sustainable. There's no evidence to sustain it. So that's it. But it shouldn't be a surprise. Now, just for completeness sake, Chair, this matter has been ventilated in this august house before the portfolio committee ad infinitum. And it's on and on about it. When I requested that I should come and explain this, what's explained in the Zondo Commission, Mr. Bjekman refused to let me come and explain the side. So they started a long process which then culminated in my suspension then, together with Werksman report. No consideration of the totality of evidence that was there. So, and it's not the first time, and it happens a few times. Honorable Chairperson, in this august house, it happens a few times when that happens.
Just explain to us, Mr. Beekman, those people who may not know who you're referring to.
Oh, Mr. Bjekman was the executive director of IPID before me, and also became a chair of the portfolio committee of police. Prior to that, he was a National Party member, and with the collapse of the National Party, he joined the ANC. It was during, I think, floor crossing period or something. So he was beholden to be told what to do. And so he closed his mind.
Honorable Sangoni.
Thank you, Chair. Good morning, Mr. McBride. Sorry, that sentence sounds incomplete. Through you, you said he was beholden to be told what to do. By who?
I reckon by my fellow comrades in the ANC who had convinced themselves by whatever they were told by the then senior member of the ANC, Nkosi Nhlego.
Honorable James.
Thank you, Chair. I raised my hand earlier on, I think twice. You didn't recognize me, and I'm going to go back to the same question because it's relevant now. You mentioned that there was a plot against General Sibia, and you mentioned that all the statements given was incorrect by the members within SAPS. Who were these members?
The people who made the false statements.
Yes.
So it was, I don't remember the names off by heart yet, but it was the same people, and that's what Kube explained to me. At some stage, General Sibia, and here's where the problem starts, arrested General Mdluli, Richard Mdluli. And during the appearance of Richard Mdluli in the court in Johannesburg, a number of armed people were putting the proceedings under surveillance, and Sibia and his fellow officers approached them, and an altercation ensued, ultimately which led to the arrest of those people. And those people describe Sibia in a particular way, a tall man in a gray suit and driving a BMW. Now that same description of him mysteriously comes up by the same people of crime intelligence. By the way, those people of crime intelligence, honorable member, they were crime intelligence members, and the name comes up again in this rendition issue as the statements supposedly implicating Sibia. But where they placed Sibia on the scene, Sibia is 100 kilometers away from there, from the cell phone records which were obtained subsequently. So in my mind, it's a stitch up. It's a fabrication. And that's what, according to Kuba, what gave him an idea to look is that he investigated both cases. So that's how he remembered the statement in the other one. And then it became clearer afterwards when we got the cell phone records. It can't be unless General Sibia has the ability to bilocate and be in two places at the same time.
Okay, Mr. McBride, you can stop speaking.
Not quite, Chair, because political interference and factions is what we are probing within SAPS. And Mr. McBride takes us back to 2014, and he says that the factions actually and the people that we are dealing with, are they still employed within crime intelligence? Okay, thanks.
My apologies, Chief Whip. I can't say definitively, but from my knowledge, there still are.
I want to get indication from you, Honorable James. Are you satisfied? Anything, Honorable Sauls?
Partially satisfied, Chair. I just would have wanted
Anything,
name.
Honorable Matthys? Honorable Ntuli?
No, nothing on my side at the moment.
Honorable Mngango?
Well, nothing on my side. Thank you.
Honorable Sangoni?
No, nothing, Chair.
Honorable Sokanyile?
Nothing, Chair.
Honorable Ngola?
One thing, Chair, let's go to a break.
Honorable Nomvalo?
Nothing, Chair.
Honorable Shongwe?
Nothing, Chair.
Charlie?
I think I must take a little bit of time to really make some follow-up questioning, which might take around 15 minutes, Chair. Do you allow me?
No, it's your time, I mean.
Thank you, Chair. So no member should intimidate me then. I really thank for the opportunity, but I'll come back at a later stage. Thank you, Chair.
Honorable Breitenbach? Honorable Kuala Barnard? Honorable Cameron? Honorable Topa?
I'm fine, thank you, Chair.
Honorable Vessels? We will come back at 14 hours. Thank you so much, Advocate RNC and our witness, Mr. McBride. Thank you. 14 hours, Mr. McBride, you are sitting on that chair at 14 hours.